So in the previous lesson, we spent a little bit of time talking about how the presumptive resulting trust arises in circumstances, and we talked about things like, for example, the voluntary conveyance. And we talked about the idea of the equitable maxim that what equity will do is presume a bargain rather than a gift. It never presumes a gift. It is up to the parties to rebut that presumption. And that's what the purpose of this lesson is going to be, talking about the ways in which this presumption may be rebutted. How does one rebut the presumptive resulting trusts? Well, like I mentioned, previous lessons spent some time examining the presumptive resulting trust, and in this lesson specifically, we will talk about the ways in which a presumption of this nature can be and would be rebutted. So just as a quick recap on the previous lesson, we noted in this previous lesson that equity will presume a bargain and never presume a gift, and that there are certain situations as a result of which that equity will not presume a gift and therefore a presumptive resulting trust will exist. This is only, however, the starting point for the courts, and the courts will basically begin on this basic reflection. And it is from there that we start to think about the ways in which this presumption is rebuted, it is challenged by the parties to the case. And really, fundamentally, the first rebuttal comes from the presumption of advancement. This basically tells us that, and it will arise in a circumstance where there are a number of different contexts in which it may arise, but where there is the transfer of property from one person to another, okay? Depending on the relationship between the people who are transferring said property, it is to be presumed by the courts that this was intended as a transfer by way of a gift, and as a result of which a resulting trust will not be presumed. So, owing to the nature of the relationship, a presumption of advancement may arise, which therefore presents a situation in which it is more likely that a gift was intended by the parties in terms of the transfer, and so as a result of which a resulting trust is not presumed. So, for example, husband to wife. If a husband on their mutual wedding anniversary and their 10th wedding anniversary presents his wife with a diamond necklace or something, maybe he's a particularly wealthy man, then the courts would probably not presume a bargain and not a gift in this circumstance, given the presumption of advancement. That fundamentally here that we have a situation that it is more likely that a gift was intended by the parties rather than some kind of trust settlement being established between the husband and the wife. Similarly, things like father to child, loco parentis, all of these different examples are what you would understand to be examples of such circumstances and relationships. And I want to draw your attention to the first case that we've looked at in a while, the case of 1955 of Shepard and Cartwright. This was a case in which a father had purchased a number of shares which were registered in the names of his children. The money from the sale of those shares were then deposited in a bank account for the benefit of the children themselves. There was no presumption of a resulting trust because there was a presumption of advancement in this case. Sometime later, however, the father had gotten written permission from the children to withdraw the money. However, the children did not know what they were signing. So he got written permission on the one hand, saying that he wants to withdraw some of the money for himself, but the children didn't actually know what they were signing on to, and so it was held by the House of Lords that the children were in fact the true owners of that money. The intention by the signature would have been a rebuttal to the presumption of advancement. However, it was held that this signature of the presumption of advancement was inadmissible because the children were not aware that they were signing what they were signing fundamentally. And so, what we see here is two sort of contrasting elements at play. On the one hand, the basic facts that are established in the creation of this bank account and in the selling of these shares for the benefit of the children shows here that there was no resulting trust required because of the presumption of advancement. And so as a result of that presumption, the result of that presumption meant that the money itself was was owned by the children. However, in the circumstance in which they would have got written permission that was valid, this would have, of course, rebutted the presumption of advancement, and as a result of which the father would have the money, because they would have given them given the father written permission to take that money out. However, again, a counter to that point is that because it was inadmissible, because the children did not know what they were signing on to, it therefore meant that it was inadmissible, fundamentally. There was not an awareness on the part of the children as to what they were signing, so it rested with them, and the presumption of advancement was still valid. The most common rebuttal that you could argue, essentially, against the maxim is that it was indeed the case that this was intended to be a gift. Okay, so if there was a transfer of property and a voluntary conveyance of that kind of nature, the courts may say, well, we're going to presume that it was not a gift and that a presumptive resulting trust exists, but then the intention of the parties could just be shown and made visible by saying, well, actually, no, it was a gift. I intended to give this as a gift to this person. This evidence would either need to be expressed or implied through conduct. So I noted the previous example of a husband and wife situation and giving a necklace on their wedding anniversary. It is not necessarily the case that this should be expressed as a gift per se. That this needs to be expressly stated that this is a gift as I'm giving it to you. It could be implied through the conduct and the sort of circumstances in which that was presented, that it was a gift.